Students, how are you? This recording is totally will be in English just because of the request from the South student that they are unable to understand Hindi language. So I had already promised them that those all lectures which I had already provided in Hindi will be recorded in English for those students. And in same way I will create two playlists for Hindi and English. The students who are from South and are unable to understand in Hindi, you can watch playlist from English, and for all those who are able to understand Hindi medium can take help of videos of Hindi medium. This chapter is of NCLT and NCLT. First of all, let me tell you that this chapter has been now concise and became so small because maximum portions of this chapter has been deleted. If I am telling in earlier, there was NCLT starting from sections 406, but now it has been starting from sections 420. Major portions has been deleted from NCLT, but even them, I had tried to cover up basic understanding, basic definitions about the terms used in NCLT, because without that you cannot further move to understand this chapter concept. Why NCLT and why NCLT has been come? First of all, let me tell you, NCLT and NCLT is just a quasi-judicial body come to bring all lawsuits pertaining to companies under one roof. All lawsuits pertaining to companies under one roof. Obviously, they had replaced company law boards, industrial and financial reconstructions, and appellate authority for industrial financial reconstruction. This all has been now replaced with after coming up with NCLT. Now let's understand the terms of NCLT. What is it all about? NCLT and NCLT. NCLT is just a quasi-judicial body. That is, in simple way, we call them as a tribunal. Okay, they consist of precedent. They consist of precedent and such number of other persons. They are either judicial or technical, as central government may think fit. Okay, it means in NCLT there will be a precedent. In NCLT there will be a precedent and such number of judicial or technical member. Please mention such number of judicial technical member. It means how much number of judicial technical number, it has not been defined. There may be 20, 24, 26 as number CG try to think fit. I had given note 1 where it is saying that any person aggrieved by the decision of NCLT, if you are aggrieved, if NCLT pass an order against you and you are now aggrieved, now you can move to where? For appeal before NCLT, National Company Law Appellate Tribunal. Okay, they may prefer an appeal to NCLT. Now, what is the composition of NCLT? I had written, it consists of chairperson and such number of judicial and technical member. And such a number of judicial and technical member, but not exceeding 11. Please note, in NCLT you have such a number of judicial technical member. Maximum number has not been prescribed, but now in NCLT, in case of NCLT appellate tribunal case, there has been prescribed the maximum number of members should be 11. It means one chairperson and there should be can be maximum 11 persons who either be a judicial or technical member. That depends upon central government. Okay, and note 2 is NCLT and NCLT is providing one-stop solution to all the disputes of company. Why they had came? They had came to provide one-stop solution for all the matters related to companies. Are you able to understanding? If any students are facing difficulty, you can mail me and query me, or you can comment in YouTube. And also I request to please make this channel reachable to every person. I am saying that maximum of the viewers had not subscribed our channel. This may happen that in case I upload any important video in upcoming future, you will not receive an update. So try to subscribe that channel also, my channel also. Now let's understand about who are chairperson, who are president, and who are technical and judicial member. I had covered up definition, although definition is not applicable for your examination, but I had tried to cover it. Chairpersons, judicial member, president, technical member. Let's understand in simple way. First of all, before NCLT there was a tribunal and there was appellate tribunal. Okay, chairperson is a chairperson of appellate tribunal in simple understanding. President is a president of tribunal in simple understanding. These both terms are simple. Chairperson is chairperson of appellate tribunal. Please note, a chairperson cannot be a person of tribunal. In tribunal there will be president, and in appellate tribunal there will be chairperson. Okay. Now for judicial member and technical member, you had read that in both NCLT or NCLT there are judicial and technical members. So this judicial and technical member can be a member of tribunal or appellate tribunal. Okay, and includes, if chairperson wants to come in downward grade, they can also be a judicial member or technical member. So definition is, a member of tribunal is a judicial, or appellate tribunal is a judicial, appointed as such, and includes president or chairperson as case may be. President will be for NCLT and chairperson will be for NCLT. And same happens for technical member, a member of tribunal and appellate tribunal appointed as such. Why? Because technical member is more below grade. Why president or chairperson wants to be the member of wants to be a technical member? So in technical member you just say they are a member of tribunal and appellate tribunal. In judicial member you say they are the member of tribunal and appellate tribunal and can be president or chairperson if they want. Okay. This is the definition as covered in sections 407. Now coming to major portions that will be asked in examination, that order of tribunal, sections 420. Let's give a brief in order of tribunal, section 420. What is saying? Order of tribunal. Okay. After hearing the parties who came before tribunal, tribunal shall pass an order. After hearing the party, tribunal will pass an order, what he will think fit. Okay, but please note, if in order there can be a mistake by tribunal, if in his order there can be mistake by tribunal, that mistake can be rectified by him within 2 years only. Within 2 years. Means maximum period allowed for tribunal to rectify their one mistake is 2 years from the date of order. Okay, but what if, sir, tribunal has passed order and aggrieved party reached to appellate tribunal, then can order be revised? No. If appeal has been made, then you cannot revise your order. Okay, and after passing order, tribunal has to send the copy of order to all the parties involved. This is all 420 is about. 3 points to be noted in 421. Tribunal, after hearing the parties in good faith, shall pass the order. His order, second point, his order can be rectified within 2 years. Okay, but if appeal has been made, no amendment will be possible. And third point, he has to give copy of order to all parties involved. These 3 points are considered in 420. Read now let's read the literature of Bear Act. A tribunal may, after giving a parties to the proceeding before it a reasonable opportunity being heard, after giving a reasonable opportunity being heard, in such shall pass the order. Tribunal can within 2 years from the date of order, with a view to rectify any mistake apparent from record, just with a view to rectify any mistake apparent from record, may amend any order passed by it and notify the parties involved. Please note, if appeal is made, amendment will not be possible. Tribunal shall send copy of every order passed under these sections to all the parties involved. Now let section 421, appeal from the order of tribunal. Can we make appeal with the order of tribunal? Yes. In short, if I will tell you, appeal, every party can make appeal. The period of appeal should be 45 days. But if you have reasonable cause, then you can move further for extension of your period, and total period of appeal can be 90 days. Okay. And third point should be, after passing order, copies of order should be given to the concerned party. It is short brief of sections 421. Let's understand the now literature. Let's read in literature what is saying. Any person agree by the order of tribunal may prefer an appeal to an appellate tribunal. Obviously, if I am agree with the order of tribunal, then I will go to appellate tribunal for appeal. That order has been passed against me and which is incorrect. Note, no appeal shall lie to an appellate tribunal if earlier order was made with the parties concerned. What is this saying? It is saying that if tribunal has already asked me, are you satisfied with my order, before passing an order, and at that time I had told him that I am satisfied, it means the order was passed with my consent, and now I am again appealing, it will be not possible. If order is passed with the consent of the party, then and after that appeal will not be possible. Second point, appeal should be within a period of 45 days from the date on which a copy of order of tribunal is made available to the aggrieved party with fee as required. Time period for appeal is 45 days. Note, appellate was prevented by sufficient cause for delay. If you have delay of sufficient cause, then also appeal can be entertained after 45 days, but within next 45 days. It means 45 plus 45 actual period is 90 days, including extension period. Okay. Now third point, let's read. What is this? Appellate tribunal shall, after giving a party to the appeal a reasonable opportunity of being heard, pass the order. Obviously, without complying with the provision of natural justice, that is after giving opportunity, before giving opportunity you cannot pass order. So before passing order you must have to give parties opportunity of being heard, and after that you can pass order and can send the copies of order to tribunal and parties involved. Okay, this is all 421. 420 is about order of tribunal, 420 is what? 421 is appeal. Okay, order of tribunal can pass after giving opportunity of being heard. 2 years have been given for tribunal to amend his order, and he also have to send these copies to parties involved, and same for 421. Appeal can be possible, maximum period 45 plus 45 including extension, and copy of order should be given, and order even in appellate tribunal order should be passed with the opportunity of being heard. Now 422, expeditious disposal by tribunal and appellate tribunal. This is all about if any applications come before tribunal or appellate tribunal, what is their responsibility to dispose that case. If I am a tribunal and I receive applications, then how should I resolve that issue? Okay, this is all in 422. Let's understand. Every applications of petition presented before the tribunal and every appeal filed before the tribunal, any case coming before tribunal or appellate tribunal, okay, shall needs to be disposed of within 3 months. Okay, if I receive application and I am a tribunal or appellate tribunal I am, then I have to dispose this case within 3 months. Okay, from the date of receiving application, and if there is sufficient cause, then this period can be extended for further 90 days. It means total period will be 3 months plus 90 days including extension. Further period will be 3 months plus 90 days including extension. I hope you are understanding it better. I have written this. If there is a sufficient reason for not disposing within 3 months, if I am unable to dispose the matter, I am unable to complete the case within 3 months, then after recording the reason to it, and if the president, my honor, president or chairperson, president of tribunal and chairperson of appellate tribunal, if satisfied that there is sufficient reason, then they can extend period for further 90 days. Okay, this is the time period to dispose a case. Hope you are understanding. Now let's move to further. Section 423. Appeal to Supreme Court. What is now this appeal to Supreme Court? If any person agree by the order of tribunal, he goes to appellate tribunal. If any person agree by the order of appellate tribunal, now we will go to Supreme Court. For appellate tribunal, you have time period of 45 plus 45. And now for Supreme Court, you have time period of 60 plus 60 days. Always note. This means here you have time period of 120 days, including extension. Now let's read the Bare Act. What is this saying? Section 423, appeal to Supreme Court, 60 days plus extension 60 days. Any person agree by the order of appellate tribunal. If I am agree by the, even I am agreed now, after even passing the order of appellate tribunal, may file appeal to Supreme Court within 60 days from the date of receipt of order of appellate tribunal to him on any questions of law arising out of such order. Provided that Supreme Court may, if satisfied that the appellant was prevented by sufficient cause of filing delay, if I have actual reason why I am delayed, that I cannot file appeal to Supreme Court within 60 days, then I can get an extension period of further period not exceeding 60 days. So I had in short I had written here 60 plus extension 60 days. Okay, this is 423. Even a person get aggrieved by the order of appellate tribunal, he can go to appeal to Supreme Court, and there should be a minimum period of 60 days, and if he have sufficient reason that why he had not present the case within 60 days to Supreme Court, then extension of further 60 days can be allowed. But note, no further extension will be possible after 60 days extension. Now let's move to read section 424, procedure before tribunal and appellate tribunal. I will say you, this is very simple procedure. Every tribunal or appellate tribunal, before passing or before hearing any matter, okay, they have to follow rule of natural justice. They have to follow rule of natural justice. They have to give opportunity of being heard always to the party concerned before passing an order, and they have all the power and privilege is provided in civil code of civil procedure 1908. Okay, and every proceeding done to resolve the case shall be considered a judicial proceeding. I had written this in short, but now let's read in detail. Detail is so long, but I had considered in short. This is not so much relevant for examination, so you can go even after reading this point. Now let's read in detail. In detail there is the tribunal and the appellate tribunal shall not, while disposing any proceeding before it or each case may be an appeal before it, be bounded by the procedure of Code of Civil Procedure 1908, but shall be guided by the principle of natural justice. Yes, they have to follow what they have power. They are within a power limit of civil procedure 1908. What is their power? They cannot go beyond the power, but they have to also follow rule of natural justice. Okay, I had written in red, but subject to the provision of Company Act and IBC. If in Company Act, if somewhere they are written, they don't have to follow natural justice, means they don't have to give opportunity of being heard, then tribunal or appellate tribunal can do same can pass order without giving opportunity of being heard. Note, any order made by tribunal or appellate tribunal may be enforced by that tribunal in the same manner as if it were disease made by court in a suit pending therein. Okay, any order come before tribunal or appellate tribunal, okay, they can take like a disease made by court. Okay, it shall be lawful for a tribunal or appellate tribunal to send for its executions of its order to the court within a local limit of whose jurisdiction. In the case of order against the company, the registered officer of the company is situated. Note that the code of power of civil procedure. Don't try to read all the power of civil procedure. Don't try to learn 2 or 3. Power of civil procedures are summoning and enforcing person and taking them, examining on oath, requiring and discovery and production. You can go and discover and produce, or you can search any books. Okay, you can issue commissions for the examination of witness. Okay, you can dismiss any representations for default. Okay, you can set aside, okay, and of any order of the dismissal of any representations. Okay, this all are small, but you just try to learn only 2 to 3 points. First, showing and enforcing of attendance of person and examining them on oath, requiring production and discovery of books. Okay, okay, and then take dismissing any representations for default. Okay, also issuing commissions for examinations of witness or document. No need to learn so much of details. Okay, they are not much applicable for examination. Section 425 now, power to punish for contempt. Now learn this. This is what law is saying. Power to punish for contempt. As if anyone did not follow order, then tribunal or appellate tribunal have power as that of High Court have to punish for power of contempt themselves. Means if you don't follow the what tribunal or appellate tribunal is saying, then you have a power as same like the power of High Court to entertain this matter. Okay, here is saying read tribunal or appellate tribunal in contempt of court act wherever High Court is mentioned. The tribunal or appellate tribunal shall have the same jurisdictions and power and authority in respect of contempt of themselves as the High Court has. Means tribunal or appellate tribunal now will have same power in case of contempt, power of contempt, same power is same like that of High Court. Okay, this is written. And also it is written wherever there is written word tribunal or appellate tribunal, then for power of contempt you try to read them as High Court. Okay, this is so simple. 427 but not relevant for examination. 425 is not relevant for examination, please note. 426 delegations of power. As obviously tribunal and appellate tribunal can delegate their power to officers, employee or any other persons, okay, as they think fit. But also they have to pass order for delegation of their power. Tribunal or appellate tribunal may delegate their power or work to officers, employee or any other person with such condition as they think fit. But here also they have to give order of delegation of power. Okay, this is so small section 426 saying that tribunal or appellate tribunal can delegate their own power to other persons if they needs, it is necessary. It is now written in detail that the tribunal or appellate tribunal may by general or special order direct subject to such condition if any, as may be specified in the order, any of its officer or employee or any other person authorized by it to inquiry into any matters connected with any proceeding or as case may be and appeal before it. Okay, this want to just say that if I am tribunal or appellate tribunal and I want to delegate some of my power or all of my power to any officers, any employee or any persons, then I can, after passing a special or general order, delegate that power to them. Okay, section 427, that this is saying that presidents, chairpersons, members, all the elements which are in tribunals and appellate tribunals, they are a public servant. Means they are public servant and they are for public's help. So they can take bribe. They can do any illegal actions. Okay, this is written. Read president, members, officers and other employee of the tribunal and chairpersons, member, officers or any other employee of appellate tribunal shall be deemed to be the public servant within the meaning of section 21 of Indian Penal Code. You don't have to read this section, but you just have to read that they all are government employees, hence they are our public servant. They are for public help. Okay, this is what 427 is saying. Now 428 is important, okay, and can be asked in May-20 or November-20 examinations. This is important, that protections of action against good faith. I had written in short, please again read this. In whole chart, I had given summary also and in detail analysis also. So you can summarize yourself also and read detail of Bare Act provision also. In summary, I have written, if any work is done in good faith, then person making order will not be liable for any proceeding or prosecution or any loss of damage. Let's take example. I am a tribunal and I had passed an order in good faith, but my order has caused serious damage to Mr. B, who was an applicant. Now, Mr. B cannot claim compensation from me because the order which was passed by me was in good faith, and I am protected by section 428. As 428 is saying, if any order has been made in good faith, then no one can claim compensation and no one can file suit against me. Okay? This is what detail is written. No suit, prosecutions or any legal proceedings shall lie against tribunal, the president, member, officer or any employee, or against appellate tribunal, chairpersons, member, president or any employee thereof, or liquidator, or any persons authorized by the tribunal or the appellate tribunal for the discharge of any functions under this act, in respect of any loss or damage caused or likely to be caused by an act which is in good faith or intended to be borne in pursuance to this act. This is detailed, word are detailed, but I had compiled this word and put you in short brief that no compensation shall be allowed if my order will be in good faith, even it makes harm to persons. Section 429, power to seek assistance of Chief Metropolitan Magistrate. I had again written in short and summarized that. Let's read this summary first. In case of winding of any proceeding, tribunal and request of Chief Metropolitan Magistrate, Chief Judicial Magistrate or DC of any jurisdictions where the book's property is being placed, to bring them for tribunal. Okay, CMM, JMM and DC, and do any act to bring that property. No one can question their act in any court of law. What is this saying? That we have power. If in case of proceeding, we are taking any person's properties, any person's information, books or document, no one have right to question our work. Okay, this can only be happen if we are in proceeding. Our operations has running, and during our operations to dispose of the applications, we had gone and bring any books, notes and our document, then no one can have right to question us that why we are doing this action. Okay, now this is written in detail. No need to read in such detail. Okay, I have already summarized. Now read note 1 and note 2. This might be important. Note 1 is saying that for the purpose of securing compliance with the provision of subsection 1, the Chief Metropolitan Magistrate, Judicial Magistrate or District Collector, which was DC earlier, may take or cause to be taken such step or cause such to be used such force as may be necessary for them. This means for the compliance of provision of section 429, I can take any action, any work which I feel necessary. And who am I now? I am Chief Metropolitan Magistrate or Chief Judicial Magistrate or District Collector. Okay. Note 2 is saying no act of the Chief Metropolitan Magistrate, Judicial Magistrate or District Collector is done in pursuance of this section shall be called in question. Okay. In any court or before any adjudicating authority or whatever any ground. That for complying with the provision of section 429, that is for providing information and document, no one can complain me, no one can questions me why I am doing so, because I am protected by the sections 429. Okay, this is 429, not relevant for examinations again. Section 430, civil court not have power of jurisdictions. Okay, in summary way I have written, please read this in summarized form. A civil court shall not entertain any suit or proceeding for which tribunal or appellate tribunal is empowered to determine. Means, being a civil court, I don't have any right to entertain the matter or proceeding which are lying before tribunal or appellate tribunal. Okay, I don't have jurisdictions to entertain the matter present before tribunal or appellate tribunal. Now again this is written in detail. No civil court shall have jurisdictions to entertain any suit or proceeding in respect of any matter which the tribunal or appellate tribunal is empowered to determine by or under this act or any other law for the time being in force, and no injunction shall be granted by any court or authority in respect of any actions taken in pursuance to the any power conferred by or under this act or any other law for time being in force by tribunal or appellate tribunal. Tribunal and appellate tribunal are already a big body. Okay, please, civil code, don't try to intervene in their matter. This is all about what 430 is saying. 431. Vacancy of tribunal or appellate tribunal shall not invalidate any act. Now let's what is this saying? That if tribunal has passed, I am tribunal and I had passed any order. Now might be due to my death or due to my disease problem, I cannot be now appointed to be a part of tribunal, either in the position of president or in a judicial or technical member. Now, does my order passed earlier can now be invalidated? No. Because I am protected by section 431, which is saying that no act of any or proceeding of tribunal or appellate shall be questioned or shall be invalidated merely by the reason of couching vacancy. Okay? Let's read the act saying. Section 431, no act or the proceeding of the tribunal or appellate tribunal shall be questioned or shall be invalid merely on the ground of existence of any vacancy or defect in the constitutions of tribunal. Even I am wrongly appointed and I had passed order, then after getting that I was wrongly appointed and I was now removed from the office, order passed by me will not be invalid. Okay, this is 431. Now 432, right to legal representations. Any party to the proceeding or appeal before tribunal or appellate tribunal, as case may be, may either appear in persons or authorize any one or more chartered accountants, company secretaries or cost accountants or any legal practitioner or any other person to present his case before tribunal or appellate tribunal. What is this 432? 432 is all about if applicant is coming for applications and during proceeding, if they can either come for a hearing in persons or they can delegate their responsibility to any other person as a representative. That representative persons can either be a chartered accountant, cost accountant, company secretaries or any other legal representatives or any other person which that applicant thinks that they can handle the case. Okay, means a person giving applications and during the hearing they can appoint a legal representatives for themselves. Why? Because 432 has given a power to appoint legal representatives for their own work. Now 433 is not for examinations. What 433 is? That the provision of Limitation Act 1963 as far as may be apply to proceedings or appeal before tribunal or appellate tribunal. Now, provision of Limitations Act is not in our syllabus. So, 433 will not be in our syllabus, should not be in our syllabus. ICAI had not excluded this section, but if ICAI try and read all the sections of Companies Act, then they can find many of the provisions that which will be impracticable for a student to read, just like Limitations Act. Okay. Now, section 434, transfer of certain pending proceeding. What this is saying? Now, before NCLT, there was Company Law Board, there was Board for Industrial and Financial Reconstruction, BIFR. Okay. Now, Company Act 2013 came. Any proceeding before 2013, that is 1956, then that's all proceeding, if they were pending, shall be transferred to Company Act 2013. This is saying 434. On such date, you can read all the proceeding I am saying that can be transferred. There is written in detail, but no need to read in such detail. You can, in simple way, you can say all the proceeding lying in previous act can be transferred in current act. Okay, like you can see all the matter of proceeding or case pending before Company Law Board constituted under section 1956, all proceeding under 1956, any person agree by the decision or order of Company Law Board, this is all earlier board and they all are earlier in earlier act. Now they can transfer in current act. Why? This is all because 434 has permitted for transfer. now this is your NCLT overall completed. I hope Southeast student now you are satisfied. I had tried to compromise with your promise because I don't have much time, but just for you and just I had promised you I will provide you in English also. I had started recording in English medium. Hope you are liking. Please request you to share our channels to maximum people because I am doing so much of labor for you yourself. You must have seen that my notes are completely unique in detail and in summarize. You can get both the things in completely, and design of my notes is totally different from many faculties, but my labor is not going to be fruitful. So if I am helping you, please try to help us also by giving these notes, by giving these videos links to maximum your friends, so that they can subscribe our channels. Okay, and again I am saying the YouTube policy, until we don't receive 1000 subscriber, our YouTube will not suggest our video to maximum students as a suggested video. Please try to help us. We are now almost reached to 1000. Only I think 150 or 170 are left. Please help us to reach that target limit also. Thank you for watching our channel. Please subscribe our channel and wait for next chapter. For English medium there will be a special code, and for Hindi medium there will be competition at for old syllabus. Okay, all the best for your examination.